judgment वाचता, relevant paragraphs in the judgment, because there are a lot of misconceptions, wrong statements, false statements being made even by ministers of the government, which are misleading the people. And I think they should not do this. They should tell what is the correct picture, and then put so people are aware of it. And then the government, if the government knows what is correct judgment, the government will help the people for themselves first to understand what is the judgment, its implications, and how to find a way out. If the government is misleading itself, सरकार चिंतित जाल्यार, wrong चिंतित जाल्यार, फाल्यां तुमगे दारा भायर लोक आसतलो तुगे घर डिमॉलिश करपाक, आनी ह्या सायडीन मिनिस्टर म्हणटा काय ऑर्डर ना डिमॉलिश करपाक. हांव तें दाखयतलो कित कोन्न तें जजमेंटाक कित बरयलां, फाल्सिदाद कित तें हांव तुमकां सांगता, आनी आतां सद्या कित तें हांव पयलीं वाचता. Paragraph 43. How much in English and we have anxiously considered the submissions of the Learned Advocate General and the amicus curiae. We have carefully perused the judgments cited above. We find there are ample statutes in place which need to be strictly implemented in its letter and spirit to curb the menace of illegal construction. Goa has blessed us with a delightful nature which needs to be cared for and protected. The fragile ecosystem of Goa ought to be protected. There cannot be any dispute that no illegal constructions can be permitted in violation of statutory provisions. The provisions which are relied upon cannot be ignored, nor can they be breached. The importance of planned development and regulation of constructions can never be overstated. In the recent past, we have noticed that a large number of cases are filed in this court itself against inaction by statutory authorities against such illegal construction. Further, the large-scale illegal constructions are noticed throughout the territory of Goa. Such constructions are put up in breach of the statutory provisions and without obtaining any permission whatsoever. Open spaces are encroached upon. Paddy fields are being converted without any permission and in breach of the statutory provisions. Roads and road widening areas are encroached upon without any authority of law. Illegal constructions are also put up in no development zones. The competent authorities either do not take action against such illegal activities or avoid taking such actions. This has resulted in wholesale change of the landscape in the state of Goa by such wide and rampant illegal constructions without any authority of law. We are satisfied that time has come to curtail, stop and remove such unauthorized construction in terms and in accordance with the statutory provisions. We therefore deem it fit to issue direction to the various authorities to act in a time-bound manner and take action in terms of the various statutes. हे पहिले तुम्ही पडले हायकोर्टात कितें म्हणला काय फॉलो करूं जाय, कोण ना जाल्यार मागीर आमी येता ताका तेका डायरेक्शन दिवपाक. हे जजमेंट हो फाउंडेशन आहा जाल्यार सरकाराक नाल्यार कोणाक रायट ना सुप्रीम कोर्टाक वचपाक चॅलेंज करपाक. कित्याक हायकोर्टान कांय रॉंग म्हणलो ना, हायकोर्टान फकत सांगलां कायदो आसा, कायदो फॉलो कर. So, first thing I want to make you aware, going to Supreme Court will be a waste of time. Going to Supreme Court will be completely wrong step on the part of the government, and that's why the government is not going to the Supreme Court. In paragraph 44, 8 categories guideline, and now directly 46 avita, paragraph 46. First category. आता first category and the second category identical. First category focus municipality area, second category panchayat area. Now in first category was all municipalities and CCP are hereby directed to conduct inspection of all the roadways, highways, major roads within their jurisdiction and make a report of any illegal construction that may have taken place on the edge road widening area abutting such roadways, highways, major roads. The reports shall be filed in this court within a period of 4 weeks from today. Upon paragraph 47, upon preparation of such reports, the chief officer or commissioner shall take immediate action against such illegal constructions by following the directions of the Supreme Court in Ahmedabad Municipal Corporation. Or judgment फकत सांगता केन्ना एक्शन घेतना तुम्ही नोटीस दिवपाक जाय. कोणा पासून कितें इलिगल केलें जाल्यार ताका रायट आहा नोटीस दिवपाक. इवन क्रिमिनल आसा a right to a notice, a fair trial, and then a judgment. So, a notice the Buddha. Notice shall be issued to the violators to demolish the illegal structures within 15 days from receipt of the notice, failing which the chief officer shall cause to remove such illegal structure within 15 days thereafter. Aporote macha vasta. Notice shall be issued to the violators to, what is that word? Demolish. Akita samta. Aho dakoyko magi minister uloyतात सांगपा हायकोर्टा ऑर्डर काय ना म्हणून demolish करपाक. SCR कोर्ट मारपाचे न्ही. In बरयला directly to demolish and cause to remove card म्हणला. In appropriate cases, chief officer shall seal the commercial structures where there is no construction license granted by municipality CCP, no technical clearance granted under the wall and so and so. Upon receipt of reports from municipality shall inspect so and so. Aweche rata comment mata. As a lawyer, I have a right to comment. With great respect to Sarpanch and Sangla High Court comment mata. We can comment even if it is wrong. I can tell you that. Don't worry about that. If you tell a comment in fair, I will tell you things what have to be told here. Same rule is there for panchayat. Second category, only who thought change kala. Panchayat and panchayat secretary bola kala. High Court ache ata in bola. First thing, High Court is concerned with constructions on the road winding area. You understanding what I am saying? So, cause me your answer. Question which you asked. Hand carts. That's why I said wait, I will answer that. Hand carts are not construction. So, the High Court order does not cover hand carts. Got it? Second, but they must be hand carts. The moment they are permanently rooted into the ground, they become permanent structure. Please understand this. There must be a movable handcart. Permission has movable handcart. Correct? So if aloina or aloina move konna, that is a different matter. It should be movable. You understand? So whether you lift it with your tires or lift it with 4 people carrying it, it should be movable. So that is the first thing you have to do. Second thing is, so the High Court has not passed any order on items which are not construction. You understand what I am saying? So it is only limited. First part of it is on any illegal, para 46. Let's see that on 46. And make a report of any illegal construction that may have taken place on the edge of the road. You understand? The word is very clear, construction. You demolish the construction. A movable cart will be removed, will not be demolished. You understand? So the High Court was very clear, and when we read the words in a judgment, we read it as it has to be read. Now I told you, I have my own reservations on the High Court judgment on this part regarding road widening. Every 10 years we generally have a regional plan. In PD areas, a ODP yaga. Generally 10 years. But आज सध्या की जाता chairman change जाता तो push करता तो ये आने के ODP काटता. So it keeps there in ODP areas. We have made noise in assembly. Every time chairman comes, he starts making a new ODP. But by law it says every 10 years. And every 10 years, a new regional plan cuts there. आज तो पढ़ो एक रस्तो हा तू फ्यूचर डेव्हलपमेंटाची चिंता तेन्ना तू रस्तो वाडयता proposal to make let us say 10 meter road to 25 meter road and 25 regional plan आ पळोवंक जाल्यार 25 meter road आमगे इगो सगळे वयतले सिमिटरी वयतलो everything school every house along this road up to Bastora will go, which is not the intention. That's why I said when the High Court speaks about the constructions which are in the road setback area, I'm saying this slowly, speaks about illegal constructions in the road widening or the road setback area, which means if you have already built your construction legally before the new regional plan, your structure is perfectly legal. Because new regional plan applies prospectively, cannot apply retrospectively. Am I making this clear to you? So today's 25 meters cannot affect existing compounds, houses. They will be saved. So I felt the High Court should have clarified, because today I got a call some days back when the judgment came from a secretary of a village panchayat, not our constituency, other constituency. Then about 6 or 7 of them called me asking same question. Sir, what about the old houses? What about the old compound walls? How do we go on measuring everybody? They are all within road widening area. So I said it cannot be that. By that time I had not seen the judgment, but that, the news was there. I said till I see the judgment I will not comment. But after seeing the judgment, I advised them that this is the law. It will apply. Now if a new construction is coming after the enforcement of the regional plan, those constructions automatically a town planning will mark the line. Town planning will say no development in this area. And after that, if you still build, that is at your risk. Please ask.
Based on the new regional plan, the new bylaws laid down by the court will be set. So, if you are saying the entire road is 25 meters as per the new regional plan, so where do we stand with the market?
As far as the market is concerned, government projects have got a different exemption. There's an exemption for government projects.
Okay.
And number 2 is the market is not totally demolished to re-erect. You understand me? So there is a provision by which, if you remember when that Fort Aguada matter was being taken, when next to the Aguada jail, down. I was the one arguing the petition.
The value
yeah, I don't know what it is. But some jetty was coming and all that. That is the time I stopped the hill from being cut. We got the order stopping them. But the lower part, the question came whether in view of the regional plan, they said for government projects that the town planning laws will not apply. Then they have a circular. Number 2, there is a misdirection of the interpretation of the High Court judgment. And third, finally, everybody will be panic mode for that reason, for no reason. Now, I have already spoken of first category and second category. Now, second category, just to show you, I'm not reading everything again. I will read paragraph 51. Paragraph 51, this is about panchayats. This paragraph is like copy-paste of the previous paragraph. Only it says Sarpanch, Secretary of the Panchayat instead of municipality, CCP, Commissioner and all that, Chief Officer. And again it says, notices shall be issued to the violators to demolish the illegal structure within 15 days from receipt of the notice. You understand? So it is there already. Now, we go to third category. That is paragraph 54. The third category is illegal construction in panchayat areas being used for commercial purposes. On this title, we got illegal constructions. Whether it is agricultural, non-agricultural, forest, non-forest, anything. Any illegal construction, even if it's a residential house, being used for commercial purpose. You understand? Illegal construction. It's an illegal one, not a legal house. Any illegal construction in panchayat areas being used for commercial purposes. Here the panchayats are directed to conduct inspection of illegal structures being used for commercial purposes within their jurisdiction. Then upon the report being filed, panchayat shall cancel the trade licenses, if any, obtained by the proprietor of such commercial establishment, and show cause notice should be issued. The panchayat shall initiate proceedings under section 66 such a power asa, license or construction modification revoke and even to issue notice for demolition. But High Court goes further to say, Section 66 of Panchayat for demolition of such illegal construction. Why I am highlighting these words again and again? Because I will then play what the ministers talk, nonsense what they talk, and say there is no order for demolition. Then fourth category, illegal construction in municipal areas and CSP areas being used for commercial. It is identical. Am Telangana, but again 2 wards of municipalities are there. दोन भाषेचे आसात, दोन मिनसाचे. एक, हांव ओनर शेत म्हजें. दुसरें, हांव ओनर म्हणून एक टेनंट आसा. Those are tenanted agricultural. And High Court has 2 category केले. One is illegal construction in paddy field. हिंगाय म्हणला ते रिपोर्ट करून para 59. Upon submission of the report, the video within judicial about illegal measures on paddy field is found to ensure that the same is demolished by following due process of issue or notice by giving writers of timber demolished building. So even on a paddy field, it can be demolished. I have a little reservation on this. कित्याक तूं जाणा आमचे एग्रीकल्चरल प्रॉपर्टी आसा तेन्ना आमचे कन्वर्जन मागता. If it's not tenanted land, if it is simply shown as agricultural property, we can ask for conversion. In some cases, paddy they don't give, sometimes they give. So the question is, if we can ask for a conversion scenario, I think people should apply for regularization by asking for conversion scenario and also getting your construction license. So if this is an illegal construction in paddy fields, the moment you get those permissions, your structures become legal. Now, 6th category, illegal construction on government property. The Talati, again now this will be inspection of government property. And remember what the High Court says. The report, para 62. The report shall also contain the particular of whether the revenue records from 1 and 14, the name of only the government features in the occupant's column or otherwise. Upon submission of the report to the deputy collector in cases only where the government's name features in the occupant's column in Form 1 and 14, the respective deputy collector within whose jurisdiction the said illegal construction has taken place shall initiate action against such illegal construction under the Goa Land Prohibition Act 95 and by following direction of the Supreme Court in the case of so and so, the deputy collector shall initiate action and take its logical conclusion within 4 months. Now, para 64 is important also. In cases where the occupant's column in Form 1 and 14 contains the name of any other person along with the name of the government, the respective collector shall initiate action against such illegal construction under Section 40 of the Land Revenue Code 1965. I feel that to classify it as a government land, survey formaचे सरकाराचे नाव आसूं. High Court clear. Third party, survey formaचे सरकाराचे नाव आसा आणि कोणाचे नाव आसा. There can be 2 parts of it. One is, why is that other name in the survey form? कित्याक आसा? सरकारान मुगे फुडें प्लॉट आहा ते पार्ट एक्वायर केला, रस्तो वाडोवपाक आनी कितें करपाक. सो मुगे नांव आसूं ना थिंगा आनी सरकाराचें नांव आसा. Please understand this. It is not that I have illegally put my name in that survey. I am the original owner of the plot, but government has come in later. I think the High Court has missed one point over here. The High Court should have said, conduct an inquiry, not simply direct take action under Section 40. Section 40 of the Land Revenue Code is to remove an encroacher. Yes, remove an encroacher, an argument the judges can make back to me by saying, we only said remove an encroacher. But why should I get a notice if I am legal owner of the land, part of the land has been taken by the government? You understand this?
You have said
High Court judgment. You read it? Did you read it? Did you read? No, that's why you wait. I will read. There is is a separate category for Kumlidal lands. I am coming to that separately. So, again now, government land, you understood? There is another category of government land. Sarkaran tuka zumin dile. And then, you get also lease period cover zalo. Or you have violated some conditions. You have not paid the rent. You have not done anything for many years. That is section 14. Where the government can remove an encroacher, or your license lease period is over, or you violated conditions, they should notice to you and remove you from that. Please understand this. As far as legal owners are concerned, in my view, this High Court direction will not apply to the legal owners because they are not illegal encroachers. Get that? So, stop agriculture. But we will have like a walking track. We will have the food stalls around it, benches for people to sit. And that I would go and ask my close friends, not even CSR. I somehow don't like this word CSR. CSR is what I do, you do for me back. You understand? So if tomorrow any notice comes of illegality, Panchayat has to keep quiet because he gets some funds for CSR. I'm talking where my friends who have nothing, they are not developers, they are nothing in this constituency, are ready and willing to help me to make this a reality. I'm looking for the land. If you can identify for me, which is not far away from this area, you can identify for me, I will get all the permissions. And remember, even if it's a tenanted agricultural land, I will make sure it is put to use without contravention of the law. Understanding? So I want to have that where people can sit. They will sit under some nice trees. There will be no such type of structures. We will have food carts. But give me the land and I will do it to you. I don't want land which is being cultivated. Then tomorrow people will shout. Good. Cultivable land is going away. I don't want that. Non-cultivated land, you give it to me. I will do it. I will not ask any one of you for any help. I will have my friends who will help me. Who, I repeat, have nothing to do with this constituency, or just my friends who are ready to help. But give me the land and I will